We're going to explain to you some very complex things and intertwined things when it comes to truth in lending, the issue of notes, and the issue of mortgage. At this point, I trust you know that mortgage is anything that you put your hands to by pledging something. At this point, I assume you know that Article 9 deals with mortgages, aka secure transaction. When you see this word secure transaction, it's no different than saying a collateral. Article 9 deals with, an entire article deals with collateral, how you use collateral, how you monetize collateral, how collateral is transferred, the priorities within collateral, who has the right over it. So I assume you know that Article 9 deals with mortgages, because mortgages is just a separate document that basically says, hey, you have this collateral that you're using in connection with what Article 3 says, negotiable instrument, connection with a promissory note. Article 9 governs mortgages. Article 3 governs promissory note. I would assume you at this point know this as we listen to this. What I'm about to explain to you is what is lesser known, even amongst those who speak about truth in lending, consumer rights, banking, those sweet words people throw about. And I'm going to show you, by taking a step at a time, through the words of an acting judge and the words of a lawyer in a case relating to Truth in Lending Act, it reveals so much within such a short period of time that you will study for years just to get an idea that that's what's going on. Let me show it to you.
But if one document refers to the other document, the cases...
She says if one document refers to another document. Make no mistake, what this attorney is referring to is the fact that the promissory note, aka one document, is referring to another document, aka mortgage. That's what it's not used in verbiage right here. But nonetheless, they both know what they're speaking of. So they're speaking about promissory note and mortgage. You've heard people talk about if you split it, it invalidates the mortgage. If you split the promissory note from mortgage, it invalidates it and you don't owe anything, right? Remember, Article 9 deals with mortgages. Article 3 deals with promissory notes. Two separate articles. And both of those articles actually affirm the fact that they can be enforced separately. Now, to clarify the speculation that a lot of people make, listen to this and other connecting details that will tell you how truth in lending works when it comes to standards, how truth in lending works when it comes to elements. So at this point, I assume you've watched all the other videos that I've made in the past when it comes to standard, test, and element, specifically to those things or the things that I've spoken about in other videos. Standards are basically principles. Elements are basically the details of how the principles are used in summary. Listen to this. If you don't have a premise of what's spoken of in between the lines, this would just be a bunch of gibberish. But that's what we're here to clarify. Listen.
But if one document refers to the other document,
if the promissory note refers to the mortgage, if the negotiable instruments refers to the collateral, if what makes the everyday man a debtor refers to what they're bringing to the table as consideration for the banks to basically turn them into slaves. That's what she's saying.
If one document refers to the other document, the cases that allow the contemporaneous consideration.
Contemporaneous is just another fancy word for two things happening at once.
Cases that allow the contemporaneous consideration. But if one document refers to the other document, the cases that allow the contemporaneous consideration of them say that that's appropriate.
I'm having a problem with that.
The premise of this conversation is the fact that they're speaking about whether it's appropriate to split the note from the mortgage. Again, a mortgage is anything that you sign whereby there's a collateral and there's a pledge attached to that collateral, aka there's a pledge attached to that mortgage called a promissory note. Anytime you're signing something to say I owe you and I'm putting this down as a leverage, as a consideration, that's a mortgage. It doesn't necessarily have to do with real estate. It can be a vehicle, it can be whatever. And equity, all kinds of property. Real, meaning real estate. Land, when you see this term real, the legal stuff and financial stuff, real is simply referring to land. Or personal, it could be anything. And this word personal is no different than the word private, which are capable of an absolute sale, may be the subject of a mortgage, rights in remainder and reversion, meaning to give someone back what they are or to keep it in the same status. A Dictionary of Finance and Banking, 4th edition, Oxford. Mortgage, an interest in property, aka estate. In so many videos we went over the definition of what estate is. And when you see this word interest, it is the same thing as the word estate. That's why you hear people talking about my estate this, my estate this, executor this, executor that, which is another misnomer. Executor is someone who has interest whereby a trust doesn't exist, meaning it's a free-for-all. The executor could be an acting judge based on constructive trust, but a trustee is the same role as an executor, but organized without the interest of a third party. Executor is just a free-for-all thing that anyone can be. That's not organized. But anyway, mortgage means an interest, aka estate, and property. It did not say just land alone. It says property. Remember the Fifth Amendment, your properties can be anything. Your private properties can be anything. An interest in property created as a security for a loan. What does a promissory note establish? A promissory note establishes the position of a creditor and a debtor, aka a loan, or payment of a debt and terminated on payment. Meaning until satisfied, someone owes you something. And whoever is owed has an interest in a property used as a collateral. That's what a mortgage is. When you create a car loan, that's a mortgage. When you create a property loan for a house or land, that's a mortgage. When you create private contracts based on interest of in-rent properties, private properties, it can be a piece of chisel that's a cracked steel that someone says this is value. Now, engage into a contract with me.
If one document refers to the other document, the cases that allow the contemporaneous consideration of them say that that's appropriate.
I'm having a problem.
In other words, she's saying there are case laws that says simultaneously that this is what she's saying. I'm not saying she's right or wrong. Remember, we're spoken about the premise of what UCC does when it comes to mortgage compared to promissory note and how they're linked together. She's saying that there are case laws that exist that does affirm the simultaneous, aka she used the term contemporaneous. There it is. Contemporaneous, existing at or occurring at the same period of time. She's saying there are case laws that affirms the fact that, you know what, yes, the mortgage and promissory notes can be used functionally at the same time. She's saying that same case law allows the promissory note to be separated from the mortgage. I'm going to be going back to the beginning so that you can connect the dots with each word, because they're going over this so fast that it will go over a lot of people's heads because there's so much detail spoken with few words. They know what they're going on about, but most people will not. Therefore, most people will just interpret it based on their bias. As I explain it, I'm going to be rewinding it so that you now connect the dots.
But if one document refers to the other document, the cases that allow the contemporaneous consideration of them say that that's appropriate.
I'm having a problem with that. That's where I'm trying.
The premise is they're trying to figure out whether separating a split note is appropriate or not. The attorney is saying, yes, it's appropriate to split it because the same res judicata that says it can be enforced without separating it also says it can be enforced by separating it. And the acting judge is playing the devil's advocate because the other party is saying otherwise.
But if one document refers to the other document, the cases that allow the contemporaneous consideration of them.
The consideration is whatever you bring into the table as a collateral that they say they're going to take or repossess if you don't perform against the negotiable instrument, the promissory note, that puts you in the position of debtor. You don't make the money by signing the promissory note. A lot of people go on about this. The only way money is made is when banks do something called valuation. And what they do is they beforehand get you to sign a position that waives your right to that valuation, which is how money is created. According to Rule 498, they get you beforehand to sign the thing that says you're a debtor, which stamps your position to it. That promissory note that you're signing is not you making a contract. It's them beating you to the punch and preempting your ability to be a creditor. That term preempt that I just used right now, it might sound like a regular term to you, but it's not. It's a contractual term that many who make the contention of promissory note splitting with mortgage being invalidated don't know. Preempt is a bid and contract bridge. Whose primary objective are: 1, to thwart opponents' ability to bid to their best contract. Like a bid bond, preempt is a contractual term. It's a contractual strategy. It's like building a vehicle. You build the frame, you build all the different parts, you weld it together. That's preempting the actual function of the vehicle. The function of the note is the value of the note. The process of creating value to that note to say, this is now money. It's called valuation. We went over that on Patreon. I'm not going to put that here on YouTube. What they do is they preempt, they thwart your ability to have any interest in it by getting you to consent to that piece of paper to say you don't have the ability to create, aka you're not a creditor. These are contractual principles. These are contractual strategies that is used daily that many don't know about. They just go on about speculation. They tell you you created the note. No, you did not. Stop jumping in the bandwagon. Know how principles of a contract work. Preempt is a bid and contract bridge whose primary objective are: 1, to thwart opponents' ability to bid to their best contract. But here's the trick to the bag that makes you, the consumer, a sucker. According to how operation of contract work, it's not just me, it's the operation of the principles that a lot of people consent to, that they don't know, but I'm revealing to you now. Here's the trick to the bag. The creation of the value is after you sign it, but your obligation to it is usually stipulated in that contract, that the moment you sign it is where your obligation begins. What obligation? The obligation of being a debtor. So the obligation that you have oftentimes occur when you sign it, but the creation of the value that you've waived occurs after your obligation is created. That's the game that a lot of people don't know. That's the underlying principles to how promissory notes work that most people sign when it comes to collateral that they don't know. Therefore, they make conjectures, they make speculations that you are creating the money by signing the note, when in reality, the function of what's really going on based on principles of contract, it's completely opposite. This is a game that only people on the inside know, that they would not tell you. And if you listen to conversations like the ones with acting judges and attorneys, you will never get it unless you know this premise. The layman term for that is called a sleight of hand. Sleight of hand, a noun, is adroitness in deception. Deception is what truth in lending says ought not to occur in transaction. But if you don't know how the deception occurs and you're making a completely separate contention over something that doesn't even exist, over something that doesn't even apply, based on the wrong understanding of how the operation and steps in order, chronological order of things work, you're talking about something completely different. But if you knew what the sleight of hand is, if you knew what the deception was, then you'll be able to put to use regulations, Z, truth in lending, and other constitutional principles. But if you don't know, you'll be busy explaining something completely different while turning your back on the main thing that's supposed to go on. See, there are a lot of loopholes in contract because of the principles of how contract itself work. And these loopholes based on principles of contract is what they used to create a sleight of hand, aka deception, aka deceptive practice, that truth in lending says ought not to exist based on equity. They use principles that exist and is rightful, and they use it against you because they know you don't know. That's called actual fraud. Actual fraud is someone's reliance on information that they know you don't know, and they use it to your detriment, and they benefited from it, aka unjust enrichment. These are the foundational order and state of mind that you have to know about how things work. Don't make conjectures. Don't go by your personal feelings. Don't go by the hype train you hear someone tell you. Know how principles work and how it directly ties back to substantive law and the operation of it called legal things like public law. When they start to securitize, when they start to hypothecate, which are two separate things. When they start to do those two things, that's the process of bidding where people wage on it in the market. And then they get assigned, which is another principle of contract, or they do a novation, which is another principle of contract based on the value of that thing. But they preempt you from that by throwing you out of the equation. Preempt is a bid and contract bridge whose primary objective are one, to thwart opponent's ability to bid to their best contract. It thwarts your ability to begin to bid in it, to begin to have interest in it. Because clearly the one thing that promissory note stipulates is a position of a creditor and a debtor. And it clearly says in the space that you, the everyday man, aka the consumer, that you are the debtor. With some safety, and some safety is usually to the one who created it, and two, to fully describe one's hand to one's partner in a single bid. Meaning they're telling you what position they're playing. Another misconception. Now people know that promissory notes are monetized, sure, without knowing what they're trying to tell you is the actual financial term called valuation. We went over that on Patreon. That's what they mean when they say the promissory note is fractionalized, hypothecated, monetized, okay, all that derivative word. The true word when it comes to the creation of it is called valuation. Hypothecation is the process of them placing it in the market to be registered, which a lot of people don't know how that works. We speak about that on Patreon also. Securitization, on the other hand, is the process of taking different similar contract with similar equitable value and bundling it up into CDOs. So a lot of people who use the term hypothecation as though synonymous with securitization are not necessarily there. They have an idea that it has to do with someone handling it on the inside, but hypothecation is different from securitization, but it's still nonetheless deal with a promissory note. But the hypothecation and the securitization is really not when the money is made. When the money is created, it's called valuation. When the money is created, it's called valuation. When the money is created, it's called valuation. Very important to know these things. Don't just speculate.
But if one document refers to the other document, the cases that...
And these banks are not even speaking about that process at all, because that is a private process that occurs with the shareholder and the trustees, to which you've relinquished any power to any equitable value beyond the breadcrumb of appreciation of that collateral called a house. And of course, vehicles don't appreciate their liabilities on a balance sheet. So merely the appreciation of that collateral called a house is the only thing that you have the right to. The appreciation of anything else when it comes to the value of that note, you've waived it. You're not creating anything by signing the note. They are through valuation, meaning they get rating companies like Moody's and all that to tag it and say this is what it's worth, and then they use Rule 498, and then they go through the process of securitization, then they hypothecate. But the court is not even speaking about any of that because they know that's a private thing going on. That is the reason why the promissory note to a mortgage or vehicle is never filed on public record. But the mortgage always is, though, because it's there to mark up the interest of ownership, aka a lien. Because they know that's a private thing going on. That is the reason why the promissory note to a mortgage or vehicle is never filed on public record. But the mortgage always is, though, because it's there to mark up the interest of ownership, aka a lien. which refers to something else called a promissory note. The mortgage exists for the purpose specifically to be placed on public record to show that something exists privately, which is the note. And when people get foreclosed on, it is the mortgage they foreclose on, not the notes. People get these things twisted. The note has a life of its own it's living a different life. It's like having some type of entity under your basement just partying every day and you're just upstairs clueless. That's the mortgage upstairs. The promissory note is the underworld just doing its thing. What people are trying to do is to open that door to that basement, trying to see all the naked trolls partying with alcohol with crazy hair. They hear a little bit of sound of someone partying down there, but they don't really get it. And the banks don't care much for that because they know that that's the private part of the transaction, because they know private things are meant to remain private. But the public issue, which is you defaulted an agreement that you made to a note, whatever they're doing with that note and the value of it, we don't care. But you agreed to be a debtor, which is the important part. You agreed to be a debtor. That's the perspective everyone is looking at things from. You agreed to be a debtor. And because of that, you violated the terms and condition called the mortgage, which placed you as a debtor and placed a lien on the property that you are using based on one other type of use of property. Mortgage issues what they always deal with. Rarely do they deal with promissory note issues in court. This is the reason why I'm actually bringing this up, because this case actually briefly speak about it if you have the ears to hear.
But if one document refers to the other document, the cases that allow the contemporaneous consideration of them say that that's appropriate.
I'm having a problem with that. That's where I'm trying to go back to. Because the cases, I understand there are a little bit of a divergence, but when you really line up the federal...
I can just say is I understand there are a little bit of versions, meaning the promissory note has been split so much that for us to even try to dig into what's going on with it privately, it'll be a waste of time and we will never get to the bottom of it. You can do all the Bloomberg audit you want. You can never get to the bottom of that promissory note because there's just so much more. If you know how this thing works, you realize that there's so much more going on with a promissory note that people are just loosely getting on the internet through social media posts and PDFs. So he's telling her, look, I know that they are securitizing or hypothecating the promissory note once they place the value on it, but that's the key. He transitioned away from the promissory note and went back to the mortgage. Listen to this.
I understand there are a little bit of a divergence, but when you really line up the federal cases, they all refer to the fact that courts look to state law to determine when...
See that? Now he's actually transitioning to something else. He's looking into now speaking about when certain things such as truth in lending applies. So he briefly referred to the promissory note without even using that word promissory note. Then transition to the issue of truth in lending, which focuses on two things: deceptive practices based on lack of disclosure. In summary, that's just the summary of it. There are many other intricacies, but that's the two core of truth in lending.
But if one document refers to the other document, the cases that allow the contemporaneous consideration of them say that that's appropriate.
I'm having a problem with that.
See what he just said, I'm having a problem with that. You would think he's disagreeing with her because she's saying, look, the note and the mortgage can be split. But he started off by saying, I'm having a problem with that. But he briefly mentioned about the promissory note and how it's used and then transitioned to something else. That's called double speaking. If you're not listening very carefully, you would assume this acting judge is saying, no. The note and the mortgage cannot be split. You would assume that's what he's saying, but in reality, that's not what he's saying. He's just going over the promissory note issue and then transitioning to something else.
contemporaneous consideration of them say that that's appropriate.
I'm having a problem with that. That's where I'm trying to go back to. Because the cases, I understand there are a little bit of a divergence, but when you really line up the federal cases, they all refer to the fact that courts look to state law to determine when a consumer becomes contractually obligated. But how do you characterize a transaction of tariff purposes is a matter of federal law.
Bam, right there. An entirely different subject matter now, which is what a lot of people don't know, which is another thing being entertained here. People don't know that the standard to what people call consumer rights and when it triggers is actually based on state law, because each state has their own consumer fraud protection laws. Missouri does, Indiana does, Texas does, Arkansas does. Each state has their own consumer protection law. And that is the foundation as to, okay, does this even apply? And if what you're saying now apply, then they go into truthful lending to look at the elements of what you're bringing. And truthful lending has a lot of elements beyond rescission of signature. Rescission of signature is just a triggering mechanism to bring to life those different elements, which you must know, because once you do that truthful lending rescission, now you enforce it through suit. And you would have to know what the standard and elements are. And if you don't know that, state laws govern the standards of consumer protection laws, and that truthful lending, which is a federal law, has the elements involved. If you don't even know what a standard or element is in the first place, you're lost in the sauce.
Cases, I understand there are a little bit of a divergence, but when you really line up the...
He said, I understand, meaning, look, I'm speaking about the same thing you are now. I agree with you. We have an understanding. Standing under what you're saying. Don't worry, I got you. And then he transitions to say, but when you really look at it, meaning he's going to something else now. Listen to the conversation fully. There's double speak going on here. A regular man and woman will listen to this and interpret it to their favor to say, the acting judge is saying that the promissory note cannot be split for the mortgage. But he literally just agreed with her that it can be split based on case law that says that it can also be used simultaneously. It can be used one way or the other, together or separately. And he says, I understand. And then he transitions to something else when it comes to the standards and elements of your ability as a, quote, consumer, aka a debtor, which we've explained on Patreon. A lot of people going about them being a consumer. That's just another fancy word for being a debtor.
But if one document refers to the other document, the cases that allow the contemporaneous consideration of them say that that's appropriate.
I'm having a problem with that. That's where I'm trying to go back to. Because the cases, I understand there are a little bit of a divergence, but when you really line up the federal cases, they all refer to the fact that courts look to state law to determine when a consumer becomes contractually obligated. But how do you characterize it?
State laws look at when consumer becomes contractually obligated, meaning the standard. The standard to how it is determined that you are obligated to something is based on state laws. But the elements of how you now enforce whether you're obligated or not is reaffirmed in greater details on a federal level. And for things like housing and mortgages, they have something called RESPA, which is a way they settle for a housing situation when they get caught red-handed. There are many more details when it comes to different regulations. That's where you get the different letters, regulations Z, regulation C, blah, blah, blah. Right, because those go into the elements and details of how you enforce a contract. But whether or not you are liable to it in the first place, state laws were attacked. This is something else people don't speak of. This is something else people do not know. It is being brought to your attention.
Go back to, because the cases, I understand there are a little bit of a divergence, but when you really line up the federal cases, they all refer to the fact that courts look to state law to determine when a consumer becomes contractually obligated. But how do you characterize a transaction of tele purposes is a matter of federal law. And when you look at, particularly out of the Southern District, they're saying, fine, you signed all these documents at the same time.
You signed all these documents at the same time. You signed the note and the mortgage at the same time. Two different documents. The only thing the mortgage and the note has in common is the consideration called your house, called your land, even though banks rarely do things with vacant land because they really can't do much with it until you add value to it through something called appurtenance. Not apartments, but appurtenance, which is just any additive in the land, which actually adds value. So banks really don't like doing land. So the only thing that links a mortgage, a separate document, with a promissory note, a separate document, is the consideration, which is a necessary aspect of a contract. And that consideration is what they are flipping to make you a debtor, because they are turning that same consideration into what? They're turning that same consideration into a liability for you by using it as a collateral to say, we're going to take it if you don't meet these terms and conditions. They are flipping the game on people.
Up the federal cases, they all refer to the fact that courts look to state law to determine when a consumer becomes contractually obligated.
Meaning the standards.
But how do you characterize a transaction of tele purposes is a matter
of tiller purposes, of Truth in Lending Act purposes. But how you characterize those standards of tiller Truth in Lending Act purposes, aka the element, characteristics, elements, is based on federal law.
Matter of federal law. And when you look at, particularly out of the Southern District, they're saying, fine, you signed all these documents at the same time.
Which is the trick. They get you to sign different documents at the same time. While they use what you're bringing to the table against you by making it the change. As a natural person, when you look at Truth in Lending on other consumer laws, believe it or not, Fair Debt Collection Practice Act, which applies to third-party servicers who collect mortgages, that's a consumer law too. When you look at all these different consumer laws and different regulations, they let you know that all these things apply to natural person. Many people read that and say, "Ha, yes, this is a cause for me to now say I'm a natural person. It applies to me to have a right." But in truth, it's not. The fact that these consumer laws are affirming the fact that it applies to natural person is letting you know that now the banks can attach the chain of promissory notes to you directly as a debtor, aka consumer. Do you see what's going on here? The game is cold.
They all refer to the fact that courts look to state law to determine when a consumer becomes contractually obligated.
And the mortgage is what they foreclose on. If they snatch that chain, they snatch the house with it. The promissory note is dealt with privately and quietly. In other words, here's a hint. You're supposed to have an interest in that. But the fact that you did something publicly, which is signing the mortgage, it removes your ability to have an interest in what's going on privately with the note. So the enforcement of the issue privately is the promissory note, which is the chain of most people's necks. The enforcement and the chain attached to the house is the mortgage, which they foreclose on. Two separate things. One is public, one is private. One is enforced publicly, called lis pendens, a pending suit, aka foreclosure. One is enforced privately through securitization, hypothecation, valuation. Two separate things. One is public, one is private. One is enforced publicly, called lis pendens, a pending suit, aka foreclosure. One is enforced privately through securitization, hypothecation, valuation. Two separate sides of equation that don't touch, but you consent to it though by signing that note. You can't blame them because that's the silent thing they're not speaking of here. They're not speaking of the fact that, well, you consent to it. But then it brings up the question, wait, how can I ever consent to it if I don't know how these things work? Which then triggers the requirement of truth in lending, which mandates that no deceptive practice occur. And that there has to be a quote. This is the exact term used in truth in lending, meaningful disclosure, literally. So now that's the element. But before the element comes in, aka truth in lending, meaningful disclosure, lack of fraudulent activity, which there are different types of fraud: actual fraud, material fraud, intrinsic fraud, extrinsic fraud. We're speaking about that in Patreon. Before you can begin to even talk about that, because truth in lending is secondary, which is the element, you have to speak about the standard, which is enforced by state law, which he mentioned.
There are a little bit of a divergence, but when you really line up the federal cases, they all refer to the fact that courts look to state law to determine when a consumer becomes contractually obligated. But how do you characterize a transaction of tariff purposes is a matter of federal law. And when you look at, particularly out of the Southern District, they're saying, fine, you signed all these documents at the same time. The problem is, under federal law, the risk doesn't have that contingency.
And just like that, like hypnosis, just like that, he then transitioned to another issue. He agreed with her in the first one that the note can be split, and then transitioned to how anyone can have a right to even enforce any issue dealing with the mortgage. And then he transitioned to something else. You have to have the ears to hear these things.
Under federal law, the risk doesn't have that contingency in it.
And what he transitioned to is now the silent terms and conditions that most people don't know about. All contracts usually have conditions, which is pursuant to this, or an exception that they put, or as otherwise stated, and so and so. Those are contingencies, meaning one thing has to happen first before this right occur or before this obligation occur, aka the rights and obligation of contract mentioned in Article 2 of the Constitution. So these are 3 or 4 different things that they just went over in very short period of about 30-40 seconds that can be easily misconstrued by people.
The problem is, under federal law, the risk doesn't have that contingency in it. Therefore, he became obligated. It was consummated at the time it was.
Bam, right there. Now they're speaking about the fact that in order for you to even have any right when it comes to the elements, you must look at the language of the contract that has been signed. Tell me, how many people read those contracts that they sign? Because that's where the loopholes are. That's where you cannot run away from contract law. You have to read it, because those are the binding terms. From there is where you would nitpick and say, this is wrong, this is right, this is wrong, this is right, based on the predominant elements, which is governed by truth in lending. And truth in lending is a federal public law, hence the federal public law determines the elements. And then he uses a very, very specific term that you will find in truth in lending. This very specific term is called consummation, which is the 4th thing they just casually transition to.
Doesn't have that contingency in it. Therefore, he became obligated. It was consummated at the.
Consummated. You will find this word in truth in lending a lot. Consummated, in summary, just means at what point are you obligated, which triggers the standard shown according to state law, because state laws govern when you are determined to the obligated one. At what moment are you obligated, aka rights and obligations of contract? See, the federal truth in lending and all the other regulation uses that specific term consummate or consummation or consummated as a cover term to say this is when you're liable, because no one can hold you liable unless there's a triggering mechanism. This triggering mechanism, aka consummated or consummation, that's mentioned in Truth in Lending and other regulations, is what people don't speak of quite often. You hear rescission signature, but at what point were you obligated to begin with? Were you ever obligated? The term they use to qualify the elements of being obligated on a federal level, the regulations, is called consummation or consummated.
Therefore, he became obligated. It was consummated at the time.
See that? He used the word he became obligated, synonymous with consummated. Meaning the term consummated is a triggering mechanism for obligation. They just transition to that fourth part because they all correlate.
Contingency in it. Therefore, he became obligated. It was consummated at the time it was signed. Therefore, you violated.
You hear that? The moment you sign all these documents, whether it's 5 separate documents, you sign it during the same date, during closing. The moment you sign it is where the presumption of obligation begins.
Therefore, you violated the state law. This is federal law. The risk doesn't have that contingency in it. Therefore, he became obligated. It was consummated at the time it was signed. Therefore, you violated.
What he's saying here is, in order for you to determine when you become obligated, look at the language of the contract. It will tell you. Some mortgages actually differ. Some mortgages, far eastern side of North America, they usually trigger obligation upon closing. The western side, some banks that are mainly in the western side at North America usually have a certain period, like a prorated period or some type of deferred period or some type of waiting period. That's what he's speaking of, and the language of the contract will tell you.
Under federal law, the risk doesn't have that contingency in it. Therefore, he became obligated. It was consummated at the time it was signed. Therefore, you violated TILA. Therefore, you violated the state law. This is where I'm having a problem. So that's what I'm trying to get you. Explain to me where I'm going wrong on this.
So now the acting judge transitioned from the issue of whether the note can be split or not, and went into the fact that, you know what? When did this guy become obligated to this thing? He basically said in summary, in layman's terms, look, we know the note and the mortgage can be split. I understand that. In his words. And then he transitioned to the standard of element of contract and clarified the fact that state law determines the standards, federal law goes into the details of the elements. And then he transitioned to the fact that the language of the contract, aka contingency, will tell you when it's triggered. And then he transitioned to the specific term within Truth in Lending Regulation Z, that they are consummated, aka obligated, the moment they sign it in this instant. And now he ended his own portion by leaving the floor to her with a question. When did he become obligated? This is very important. This tells you the state of mind of the acting judge in these venues. What they care for is, when were you obligated? And based on that, does something go wrong? They don't, all that thing people speak of when it comes about splitting promissory note mortgage, they don't care for that because they know those are two separate documents that are enforceable independently. What you have to be looking at is, when were you obligated? The only way you can figure out when you were obligated is to realize the fact that there's something wrong with the foundation in the first place. And the foundation that people should be dealing with is not the issue of splitting notes or not. It's the issue of the collateral. It's the issue of consideration. It's the issue of disclosure. It's the issue of bad faith, because misrepresentation or fraud, the different types, one thing they all have in common is the fact that someone knew something you did not know and relied on your lack of knowledge in the manner that benefited them and damaged you. These are the standards and cores people should be dealing with. So now let's hear it all in summary as a whole. Where about 4 or 5 different things were entertained, and the acting judge conceded to the point of their attorney by agreeing with her, and then transitioned to something else. In just a few seconds, listen.
But if one document refers to the other document, the cases that allow the contemporaneous consideration of them say that that's appropriate.
I'm having a problem with that. That's where I'm trying to go back to. Because the cases, I understand they're a little bit of a divergence.
But if one document refers to the other document, the cases that allow the contemporaneous consideration of them say that that's appropriate.
I'm having a problem with that. That's where I'm trying to go back to. Because the cases, I understand they're a little bit of a divergence. But when you really line up the federal cases, they all refer to the fact that courts look to state law to determine when a consumer becomes contractually obligated. But how do you characterize a transaction of tele purposes is a matter of federal law. And when you look at, particularly out of the Southern District, they're saying, fine, you signed all these documents at the same time. The problem is, under federal law, the risk doesn't have that contingency in it. Therefore, he became obligated. It was consummated at the time it was signed. Therefore, you violated TILA. Therefore, you violated the state law. This is where I'm having a problem. So that's what I'm trying to get you. Explain to me where I'm going wrong on this.
Clarity is the mother of all truth. There are issues with mortgages. There are issues with foreclosure. But the issue is people are not entertaining the issue itself. People are busy on speculation. The more you run away from clarity and competence and self-reflection and time to stop and think beyond what you just heard someone say that sounds good and is emotionally arousing, the more you waste your own time. Time is a law of its own, whereby the fact that your spirit is attached to a physical body, it would always feel its effect. It will favor you to really comprehend the core and principles of how things work, beyond speculation that someone has drilled in you with a lot of zeal. There's a lot of information in this world, and there's a lot of opportunities. Only you can limit yourself based on your preconceived bias. Do not allow your bias to limit you. Too many people in today's world are already doing that. All you have to do is just go to a local convenience store. You see them everywhere. The way they think, the way they interact, it's all based on bias. You, who is now using the power of the mind to figure out how the world functions, you should stop and remove bias. Stop, evaluate, and reevaluate whatever information people are drilling in you, and actually look at the substance of reality based on what actually goes on. In 21st century, you have a lot of technological luxury. You can pull videos like this up online. You can go into dockets and read exact verbiage of the intent of contractual principles. These acting judges, you might say they're crooked, but they're going by contractual principles. Contractual principles allow 2 separate documents to be enforceable separately because it's in the terms and conditions that it can be sold. Whoever signs that, aka the debtor, aka the consumer, if you sign and agree that it can be done, which most people don't even read those clauses, aka contingencies, which he mentioned, how they can retroactively come and say, oh, well, you can split the note. So the main question is what you signed and consented to. When were you obligated to it? Because your signature is what bound you to principles of contract that you didn't even read. So now the question is not what you're saying. The question is, were you even bound to it based on your consent? Based on the principles of how things work? And when were you? Because it's obvious the terms and condition, aka the contingency, says that the mortgage and the promissory note can be enforced separately. How many people have sat down and actually read an entire mortgage terms and conditions to a promissory note? Because if you did, you will see it. It's all over the place in those documents, in different clauses. And believe it or not, assignment clauses are one of those things. They might not label it in verbiage that says quote unquote assignment, but if you know the principles of assignment, you will see it clearly. And that assignment lets you know that they can assign it to someone else for a fee, and that other party can act as a creditor. And another party can have interest in the value of that thing, separate from the terms and condition that's used to mark up interest publicly, that's used to mark up that property publicly. So now the question is, okay, you signed that, but when did you become obligated to what you signed? Were you obligated to what you signed? Because truth in lending deals with deceptive practices and meaningful disclosure. Focus on that. Don't be lost in sauce and speculation of splitting notes and mortgage. I'm just being realistic with you. If this sounds a bit too harsh, or you get your emotions riled up about this, maybe you need to reevaluate what you think reality is. And if you think, oh yeah, tell them these people are stupid, these people are dumb, then you're just another man with a bias who has bigot in their heart. Take your trash of a biased, hateful mind somewhere else. No one cares about that. There's not an opportunity for you to put someone down. There's not an opportunity for you to oppose or agree to something. This is an opportunity to see the objective, reasonable reality of how contracts work. Till next time, take care. Best of luck.